The SEC vs. Ripple case was already looking terrible for the SEC, but recent developments, like John E. Deaton openly criticizing the SEC and Ripple requesting an extension to destroy the SEC claims, make the situation look even worse for the SEC. Welcome to the XRP Army. Let's help the XRP community develop by liking and subscribing. At the end of the month, we will give away 25 XRP coins to one lucky subscriber to help them continue their XRP journey. All you have to do is like the video, subscribe, and leave a comment with your thoughts on XRP in the comments section. In today's video, we'll talk about John E. Deaton publicly trashing the SEC and Ripple requesting an extension to debunk the SEC accusations. Let's get started. Despite rumors of a settlement, the SEC v. Ripple Labs litigation has already progressed into the fourth quarter of 2021. In reality, the procedures are far from over, with both parties filing petition after petition to extend the proceedings. The SEC requested a phone conference on September 29 in order to get a protective injunction. If the motion is granted, the agency will be relieved of the obligation to reply to Ripple's 29,947 admissions requests. Ripple, on the other hand, isn't the only company facing scrutiny from the SEC. In a recent interview with Fox Business, famous lawyer John Deaton revealed that he is defending 22,000 XRP investors in a struggle against regulatory uncertainty and overreach. Deaton talked about his legal battle with the Securities and Exchange Commission. In addition, he mentioned in his talk how certain SEC officials have reportedly been linked to Ripple's competing cryptocurrency, Ethereum. According to Deaton, the SEC opposed to the writ, stating that only the court where the Ripple complaint was filed had jurisdiction over the matter. Deaton later moved to intervene as a defendant in the SEC v. Ripple case. He also won an amicus status with participation rights to demonstrate that XRP buyers are not engaged in a comparable venture with Ripple. As of September 22, the motion had been fully briefed, and Deaton was now awaiting the outcome of the hearing. However, it should be remembered that Deaton has previously held XRP positions. The lawyer, on the other hand, was keen to point out that his goal is to assist XRP investors who have been damaged by the SEC decision, not Ripple. In the aforementioned interview, SEC Commissioner Deaton stated that several current and past SEC employees have conflicts of interest. He notably criticized former SEC Chairman Jay Clayton and William Hinman, director of the SEC Division of Corporation Finance. According to Clayton's previous legal practice, the Ethereum co-founders were originally represented by the company. He also claimed Hinman's previous law firm, Simpson, Thacher and Bartlett, was on the board of the Enterprise Ethereum Alliance, a cryptocurrency-focused organization. Furthermore, Deaton claimed that Hinman made $15 million from Simpson, Thacher and Bartlett while working for the Securities and Exchange Commission. Hinman is a significant character in this story. The case is complicated not merely by Deaton's claims, but also by Ripple's own defense. In fact, his deposition has been one of the most contentious chapters in the ongoing legal battle between the two parties. It arose from Hinman's 2018 lecture, in which he claimed that existing Ether offers and sells are not securities transactions. What do you think of Deaton's statement? By the way, please let us know in the comments section below. But the court case news doesn't stop there. Both the SEC and the San Francisco-based blockchain technology startup have filed a flurry of papers with the court in the case of SEC v. Ripple Labs. The SEC requested a phone meeting with Judge Sarah Netburn on September 29 in order to avoid having to answer to Ripple's 29,947 admission petitions. The conference took place on October 1. Regardless, the SEC requested a pre-motion conference on October 1 to compel Ripple to seek for and produce audio/video recordings of internal meetings in order to carry out the order. The SEC is looking for recordings of meetings in which CEO Bradley Garlinghouse, Executive Chairman Christian A. Larson, and other key personnel discuss subjects pertinent to the case. According to the Securities and Exchange Commission, the terms Ripple Video Conference and Custodian were defined in a way that hindered the identification of relevant topics. Furthermore, because of numerous redactions on a copy of the file, determining the actual nature of the recordings Ripple has already created is impossible. The SEC, on the other hand, claims that the tapes include essential information for the Howie Tetz investigation. It further argued that the search was appropriate for the needs of the case, using 4 considerations established by legal precedent to support this assertion. Aside from stating that the matter is being contested, the agency stated that Ripple owned the recordings and that, given Ripple's financial success, it had the capacity to do the search. Furthermore, the plaintiff contends that the sought-after recordings are directly relevant to the main problem they are being demanded because they are relevant to the ongoing lawsuit. Gurrier came to the conclusion that any responsibilities put on Ripple are illegitimate. Ripple's choice of naming and storing its recordings was self-created. He stated unequivocally that this will not be used as an excuse. In response to the SEC request for a teleconference in order to be excused from responding to Ripple's 29,947 applications for admission, the business has now requested an extension of time. Rather than answering on October 5, the blockchain company requested an extension of 2 working days to respond on October 7. This was accomplished, as stated in the letter, through this is defendant's first request for a time extension. Also, please leave your thoughts on the SEC move in the comments section. Furthermore, as you may have seen, a false news release claimed that the U.S. Securities and Exchange Commission has dropped its case against the cryptocurrency firm. According to the bogus XRP press release on law.com, the cryptocurrency litigation was dropped for a variety of reasons. There is also a fictitious statement from Mary Jo White, an attorney who served as the Securities and Exchange Commission's 31st chairman from 2013 to 2017. The following is an excerpt from the phony news release. In the most recent development, 13 entries classified as internal SEC papers have been withdrawn from public access following the SEC filing of a motion to protect such information. For the Ripple Army, the Ripple community, this was evidence that the SEC had something to hide, with 2 out of 5 SEC commissioners, Hester Peirce and Alad Roseman, publicly admitting that the SEC lacked clarity in the crypto field and positioning themselves on the defendant's side. The SEC found itself on increasingly shaky ground. The SEC decision to withdraw the prosecution against Ripple provides reassurance to other crypto businesses while also allowing for future industry innovation. A Fox Business Network journalist, Charles Gasparino, declared on Twitter that the news release in question is a forgery. The Ripple team is aware of the inaccurate lawsuit dismissal news release, according to his response, and is seeking to have it removed. The company adds that they did not distribute the news release directly. According to the investigation, the most recent allegation is identical to another phony press release delivered earlier this month. Walmart has supposedly claimed that it plans to start taking Litecoin payments in the near future. The story was quickly debunked, but not before it sent the cryptocurrency markets into a tailspin for a few days. Whether it's real or not, XRP has skyrocketed in recent days. What are your thoughts on the Ripple vs. SEC case? Do you believe it will be over soon? Please let us know in the comments. If you want to learn more about XRP, there are 2 more videos on the end screen for you to watch. Have a wonderful day, and I'll see you in the next video. Before you go, please keep in mind that cryptocurrency prices change rapidly, so by the time you see this video, it may have changed to a completely different value. This video's information does not represent investment advice, financial advice, trading advice, or any other type of advice. You should not consider any of the content to be so. The information in this video is provided solely for educational purposes and should not be construed as financial advice. Before making any investing decisions, do your homework and consult with a financial expert.